first directors of the clinical program, Professor John Gregory, who's still a teacher here, and the late David Cadane, took walk-ins in that second floor walk-up. They battled skepticism among the bench and the bar, and they set the tone for our clinical program, which is carried forward to this day, and that is to act as a champion and a voice for the unrepresented and underrepresented in the community. Now, with our building, with our 7 distinct practice areas, we are generally well-known and well-respected in the community. Among the legal profession and the bench and the bar, we're also well-respected, although I will say often with a touch of notoriety. Some of our cases involve representing clients and causes which some might feel or might not want to be represented. And we do that, and sometimes that brings notoriety with it. However, we still have the crucial aspects of our clinical program that's been here since the inception. And that is, as an advocate for underrepresented segments of the community through advocacy and legal storytelling. And we're here to celebrate that today, to celebrate the art of legal storytelling and how the clinic has used that art to give voice to our clients.
Storytelling plays a number of other important roles in our legal system. First, it not only assists us in presenting our clients' cases, it helps us understanding our clients' cases. When we interview and counsel most clients, especially in a clinical setting, they do not present their accounts of events in neat, logical formats. They don't express their interests in a strict outline form. Rather, they tell us stories. Some embellished for impact, some quite understated to mask guilt, some comically to avoid embarrassment. Unless we are sensitive to the intricacies of the storytelling process, we are unable to unpack fully what our clients are telling us, and are unable to provide them with full and adequate representation. Narrative techniques help lawyers identify what other evidence might exist that will compel the jury or judge to rule for them. These techniques ask the lawyer to explore the context of the party's actions, their motivations, their relationships with others, the sequence of events. Accordingly, while Dershowitz may be correct that narrative does not always mirror life, narrative forms pose for us the questions about life that help us craft compelling cases for our clients. A perfect example of this process is the recent scholarship on death penalty sentencing. This literature argues, for example, that in such proceedings, the prosecutor's story is always incomplete and misleading. Defense counsel then must attempt to expand the time frame of the client's story to include those aspects of his life that narrowed his choices, frustrated his hopes and dreams to the point that he lashed out in violence. In fact, the guidelines for the mitigation function of defense teams in death penalty cases requires that defense counsel investigate the defendant's family, extending back at least 3 generations, his former neighbors, the type of housing in the community, the economic status of the area, the prevalence of violence in his neighborhood. Those requirements are nothing more than the essentials of good narrative technique. A final function of storytelling in the legal system is its aid in interpreting legal rules. These rules and standards don't exist in a vacuum, but were developed in the life and struggles of the community. Stories fill in the gaps in our understanding of abstract legal principles, and especially in a common law system, they provide the framework for expanding our interpretation of those principles. Stories fill in the gaps. They create the context, and contrary to Dershowitz, they breathe life into the legal extractions. Faced with the injustices encountered by our clients in the clinic, narrative theory tells us that our role is not solely to logically apply legal rules to the facts of a case, but it is, in the words of Habertal, to subvert those rules, to demonstrate through stories the context of our clients' lives, the injustices in their communities in which they live or in which they have lived, and the deep meaning underlying those rules. So here, at the commemoration of our 40 years of the law school and of the clinic, I want to salute our 4 decades of challenging injustices in the community and our training of generations of subversive storytellers.
I'd like to tell you about a woman, we'll call her Ms. Santiago, who was my first real clinic client back in 2001. Ms. Santiago was a hardworking, family-oriented individual who wanted nothing more than to provide a stable and comfortable living environment for her 2 children and 3 grandchildren that lived with her. Ms. Santiago, who earned her hard-earned dollars through babysitting in the community and working long hours cleaning homes, moved into her apartment as a subtenant, originally leased to her niece. Ms. Santiago got along very well with the landlord, let's call him Murray, who made minor alterations to the apartment so that the old apartment would be more palatable to Ms. Santiago and to her family. Murray was also very happy because Ms. Santiago kept the apartment very, very clean, and he intended to extend to Ms. Santiago a new lease once the subtenancy expired. However, notwithstanding Murray's generosity and Ms. Santiago's best intentions, the relationship, then good, was about to change. Murray, who had effectively been the managing landlord, was not the only owner of the property. Murray had to answer to his sister, let's call her Sherry, and his brother, let's call him Seymour. And although Murray was himself a lawyer, he apparently was not the decision maker of the group. And close to the end of the tenancy, the subtenancy that is, Sherry came over to the apartment to look it over, checking for damages and assessing its potential value. Sherry began to complain that there was damage in the apartment and that it was a result of Ms. Santiago's use and enjoyment therein. Ms. Santiago, quite frankly, was unsure how her use of the apartment could create a leak, water damage, and chipping paint, but she kept the apartment clean nonetheless and believed Murray would keep his promise to permit her to continue living there. Then, a month later, there were complaints that Ms. Santiago's young grandchildren allegedly made too much noise, causing the upstairs tenant to move out. And then the relationship broke down completely. Murray abruptly rescinded his offer to Ms. Santiago, effectively telling her she had less than 30 days to get out. Allegations she used the apartment as a daycare center were made, although such claims were really unfounded, as the children she watched were her own grandchildren. Now, I chose to tell you about the Ms. Santiago case for a specific reason. While it's true the clinic represented those in the community that lacked the financial resources to hire private counsel, that in no way, shape, or form lowered our standards of representation or permitted us to treat our clients as if they didn't deserve top-quality representation. And that they got. Ms. Santiago is one of many stories. Justice is a relative term, meaning different things to those in different situations. Perhaps it was her lack of financial resources that led our opponents, in this case, Murray, Sherry, and Seymour, to believe our client would simply permit her rights to be trampled upon. Or maybe it was the differing ethnic and socioeconomic background which permitted the dispute to proliferate. Regardless, Ms. Santiago was a client who should have been and was entitled to proper representation, regardless of her financial resources and without any effect on her dignity. And proud she was of her hard work, her family, and her ethics. Yet even though Ms. Santiago was evicted from that tenancy, in the end, justice was indeed served. While she may have lost the case, she didn't lose her dignity, her pride, or her values. And at the same time, she obtained the services of a fine law firm with dedicated attorneys-to-be at her side. And we engaged in a zealous dogfight not only to preserve her legal rights, but also her honor. It's not always about the win in this business, although that's what we want. But in reality, and as we know about effective lawyering, it's about the advocacy which defines us.
And one thing that I think I hung on to was the fact that there was just so much hope. And I think when you're relaying a story, especially trying to persuade judges or opposing counsel, hope is a common thread. It's something that we all can identify with. Hope is an easy concept to grasp. Hope sometimes bridges the gap between two very different worlds. So when interacting with clients, your clinic clients, one thing that's important to remember, I would say, is to try to continue to tell these stories of hope. People will listen.